Abusua, Nchebia na latest breaking news by according to counsel, lawyer Martin Begbu, counsel Chema, Alfred Ebishani said, Mami Torkono wa bra say Omampenyi, the president of the republic, na according to the recommendation of the committee, giving him the mandate to act according to the recommendation. The committee would de bebano, Mami Torkono, former chief justice, the entitlement, ni sika, ni salary, ni bibia, ni sabeka, ano si debi, ni sanka, because ya sakeno, and ya de onwa resign ye, and answer onwa going to negotiation or resign ya, and can entitlement ni sabeka. Inti lawyer Martin Begbu chima, ni entitlement, ni salary, ni hard working, and ni sika, na was an insaka, ni na no ni nsa enka, ni entitlement, ni na ni sanka. Na video a Mami Torkono na ankasa make a comment of say as a regarding to about entitlement say or resigning and insabeka na nsanka no yenko na nkotie lawyer counsel nsema na oka for credit TV3 stay tuned stay connected I daily update TV so because nsema Mami Torkono nsema no say nsema no committee no nya abotre papa because according to article 146 no ope ehona procedure ni nyina efira omugina so ede enema toto baby a wose ede toto nti article 146 in connection with the constitution the president receive a petition or the council of state so mo establish a prima facie na just a committee a set up committee to make inquiries into those petitions and as into those prima facie normal establishment. Nti council lawyer Martin Begbu, private legal practitioner, and someone no worker question busa no say Mami Torkono obe lose her entitlement, and our response is yes, she will lose all her entitlement, her salary, everything. This is very bad. This is very sad. Nti council and someone no worker. She jumedi no chance ya kwetia ye bema campaign no the cost for grounds on yambo chana so activity online na ehwe jumedi ni bi so ha. Ya me show bibia.
Vice J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on.
Well, so that was it. Look, this was even an option on the table for anybody going through that process because you stand the risk of losing your entitlement. Now, with this decision that has come, does that risk also now really play out in this case, that she stands the risk of losing all her entitlements after being sacked?
Absolutely, yes. So she loses all her entitlement because the meaning of the sacking is that she was sacked on the basis that she's been found culpable. She's been found liable to have breached certain rules, okay, whilst in office. Right now, I'm sure with time, we will get to go into the rules, right, when the decision is made public. Because in the Justice Derry case, the Supreme Court said after the decision is out, that's after the proceedings are completed, the secrecy or the in-camera protection should go off. So we'll plead with President Mahama to give us a copy of the report of the committee so that we will see what findings were made. Because in the Justice Derry case, the Supreme Court was very clear that after the decision has been made, that cloak of in-camera protection, the secrecy, is no longer necessary in a democracy. It's no longer necessary in a democracy. And the Supreme Court went ahead to compare the cases. The Supreme Court is very clear that the decision can be made public, that's the committee report, etc., after a decision has been made. It's not meant to be kept secret. And in this particular case, even Justice Torkono herself had waived her right, but eventually it was generally agreed that even though she waived her right to an in-camera hearing, it was agreed that based on the decisions of the Supreme Court, etc., the provision in Article 146 asking for in-camera hearing was not meant to benefit Justice Torkono alone. It was also to protect the whole system. So it was agreed that the proceedings should continue in camera. But now that the proceedings in Petition 1 have terminated, in the Justice Derry versus Tiger IPI and Attorney General case, the Supreme Court said afterwards we can get the details, get the petitions, get the reports, so that we can dissect and see where everything went well, and if some places didn't go well, naturally people will comment so that tomorrow we will not repeat such mistakes. Yes, so Mr. Okanse, that is it. And now when it comes to the matter of there was no option to resign, remember that I said that if we wanted to get a resignation, there are 1,001 ways of doing it. But as I said, right now, we've gone past it, so it's no longer possible. So let me tell you what I was thinking. You know, matters like this, it's a civil case, right? So there could have been an agreement that, look, okay, I want to settle this case. I want to resign. Like, can I do a resignation letter for you to see so that then you will withdraw the petitions? Then she would have walked away, okay?
Right.
But as we're saying, it's because the Supreme Court said when the proceedings start, you cannot resign. There are two Supreme Court decisions. And I was saying that, because she's Chief Justice, at that time I was scared of all the places she was going to go to. Remember the time I kept saying we should allow for a resignation? You know, that time she hadn't gone to the ECOWAS court. And at that time too, she hadn't, the bar of England and Wales hadn't jumped in. So you remember we had seen that the way she was fighting it, we're going to suffer more embarrassment. So I was looking for a political settlement. And so sometimes, you know, they will tell you that the law was made for man. But, I mean, bottom line is that generally it looks like not many people sided with the resignation thing. It's a democracy, so we'll go with the majority. You remember also, yes, Lawyer Ansasari also supported the resignation route because we could have saved there and then, you know, so there could have been a settlement. This is a Chief Justice, so this is a Chief Justice, not any other Justice of the Superior Court. She's a Justice of the Superior Court and specifically Justice of the Supreme Court and also Chief Justice. So, I mean, to every rule, you hear there's an exception. But bottom line is that it didn't work. So we use the law, strictly speaking. Right. And like Justice Torkono herself had said in the past, the law is the law. So, I mean, we have to abide by it. Sometimes the law is difficult. It's painful to abide by the law, but the rule of law demands that we should abide. Yes.
Indeed. Bebo, thank you. And kindly stay with me. And this I bring in Dr. Joshua Zato. You had also indicated that for you, the Chief
Justice be removed. But Alfred, what is important to know is the basis for which the presidency indicates as the reason for the removal of the Chief Justice. When you look at Article 1461 of the 1992 Constitution, it provides the grounds for the removal of a Chief Justice or a Justice of the Superior Court of Judicature. And that particular article says that a Justice of the Superior Court or a chairman of a regional tribunal, in this case, the Chief Justice being a Justice of the Supreme Court, shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body and mind. Alfred, we do know that some persons have petitioned the president in respect of matters relating to what they say are stated misbehavior of the Chief Justice for which they wanted the president to constitute a committee to look into.
That's right.
We have seen how we have gone through the whole process of the president together with the Council of State as stipulated under Article 146, having to determine whether or not those petitions themselves even merit the constitution of a committee to look into what is popularly referred to as prima facie case. That had been determined, a committee established, and subsequent to that, the president together with the Council of State again invoking the provisions of Article 146, suspending the Chief Justice, and beginning the process to hear the petitions. We understand the report today has to do with one of the 3 petitions, and that is the Daniel Ofori petition, in which the petitioner himself had led 13 witnesses came before the committee to testify in respect of that. To her defense, the Chief Justice, 12 witnesses also came, including expert witnesses, to also testify in her defense. The end is that they've made their recommendations, and the president, having an obligation to act in accordance with the recommendations of that committee, has now gone ahead to to remove the Chief Justice from office. Alfred.
And it's a very, very, very fluid, detailed situation that we're following. Breaking news, if you're just joining us here on TV3, also on 3FM 92.7. The breaking news, as we've been just giving to you, is that the President, John Dramani Mahama, has, in accordance with Article 1469 of the 1992 Constitution. We're going to go into the specific detail, Dennis, of Article 1469, because that also is a decision based on Article 1469 of the 1992 Constitution. He has removed the Chief Justice, her Leadership Justice Gertrude Araba Esabasaki Torkono from office with immediate effect. This follows the receipt of the report of the committee constituted under Article 1466 to inquire into a petition submitted by a Ghanaian, and then, as you've just mentioned, Daniel Ofori's petition. So that clearly indicates that it is specifically Daniel Ofori's petition that the committee found.
In March this year, we received 3 petitions pursuant to Article 146 of the Constitution 1992 for the removal of Chief Justice Gertrude Asaba.
Few minutes ago, in fact, this is fresh on the committee. You had the likes of Daniel Yardomelovo, a former Auditor General, who is the chair of the Economic and Organized Crime Office as a Yoko board now, together with some other distinguished persons who served on this particular committee, this 5-member committee. Then as you hear, the chair of this committee detail the work of the committee, what they've done over the period that's led to this particular decision that has been communicated now to the president, and the president also communicating to the members of the general public, Ghanaians, as well, through this statement that we have just put on the screen. So that's the details of it. That's the breaking news right now. So this decision was guided by the Constitution every step of the way, is it not?
Yes, and Alfred, just to add that, you also hear the chair of the committee also indicate that while they were doing their work, there were also some allegations made against them, but that they focused on their work and they got it delivered. And that's very important, because when you look at some of the legal hurdles that this committee had to cross, or that had to be dealt with for the committee to do its work, some of them had to do with some of the members on the committee, particularly the chair of the committee himself had been specifically named in some of the lawsuits, and the other Chief Supreme Court Justice who happened to be on that particular committee. Also, there has also been an instance where the entire membership of the committee had been challenged, and that is part of the things that we're looking at. So the first legal action that came against the committee was that was brought by Vincent Ekosafwa, the old Tafu MP. For him, he thought that the parts of the Constitution, especially Article 146, some interpretation be placed to indicate what the procedural line should be, because his argument essentially was that once the president received the petitions, he ought to have given copies to the Chief Justice, and that for the fact that that did not happen, it was an unlawful procedure that was adopted.
Yes.
Subsequent to that, he brought an application for injunction seeking to stop the committee from doing its work. On May 7, 2025, the Supreme Court dismissed that particular injunction application. It didn't end there. By May 21, 2025, the Chief Justice herself files a writ of summons challenging the legality of her suspension. Mind you, by this time she had been suspended, and that she also sought an injunction to halt the committee from proceeding its work. Part of the averments in this particular process was to the fact that some of the committee members had vested interest in the matter, for which they should not have been part of the committee.
Yeah.
By May 26, 2025, the CJ filed an affidavit. This was a supplementary in which she made some allegations of mental torture she said that there was bias against her. And it was in this particular one that she made reference to the fact that the way in which the committee was going about its work, including how she was even searched before getting to the premises in itself, was problematic. However, this was not admitted in evidence because clearly the argument from the side of the Attorney General was the fact that this is supposed to be something that's supposed to be in camera per Article 146. And that was not even allowed in evidence in the defense. That was addressed by the Chief Justice herself, in which she addressed a number of issues, including reiterating allegations of bias and how the whole process had been impugned, for which she did not think that it was fair to her. Fast forward, by July 4, 2025, she filed the case at the ECOWAS court, by which time she was demanding 10 million in damages for what she says that was not a right process. The Human Rights Court heard the application. They are yet to deliver their judgment on that particular one. And this was in respect of the ECOWAS court. That was not done. She went back to the High Court, this time around, filing a judicial review, basically challenging the procedure that had been adopted by the committee, and also alleging the breach of human rights.
Absolutely. And these are cases that are still in motion, and the courts have not determined that outcome.
Yes, for the substantive ones, yes, but the injunction applications, those have been determined and
already
dealt with.
Perfect. And let's stay the steam on that, and let's go on to Zoom right now. Martin Pebo is private legal practitioner, and is one that we've been engaging right from the beginning of this entire process, where 3 petitions at the start. That's what we were told at the start of it. 3 petitions were received, and it was the first petitioner, Daniel Ofori's petition, that formed the basis for this recommendation by this committee headed by Justice Gabriel Scott Palmer, whom you see right there presenting the details of this report by the committee to the president. In that brown envelope, the president received it. You have all the other members of the committee as well seated at the table with the chair, Justice Scott Palmer, who presented it, the Chief Justice, that's the Chief of Staff as well, was there. And Martin Pebo is joining us on Zoom right now as private legal practitioner. Counsel, good evening. Thank you very much for joining us. And when we started this conversation months ago, you had indicated that it would have served the now removed Chief Justice some good if she had resigned right from the beginning of this. Well, the process has gone full scale, and this is the outcome. The president has communicated a decision to have her removed from office based on the recommendations of the committee and their findings on Daniel Ofori, petitioner 1's petition. Counsel.
Yes, well, so like they say, the law is the law. So at this juncture, the law has taken its course, and so that will be it. We're hoping that this will bring closure to this case so that we can, go on to concentrate on other matters of improving the judiciary. Yes, I mean, my position, as I said earlier, I was hoping there would be a window for her to resign way from the beginning. But, it didn't happen. Also the Supreme Court too had held that in the Justice Utaderi case and also in the Frankie J. Chum case, that they start the hearings, then the respondent, that's to say in this case, the Chief Justice has no right to resign. I was hoping there would be a political settlement that would have resulted in a resignation. But as I said, that was hope. But all of that didn't materialize. So once the committee is done with its work, and then that's based on the first petition alone, and once she's been removed based on the first petition alone, I mean, well, that's it. We will see whether the committee will have the appetite to go into the other 2 petitions. It doesn't appear it will be a good use of our time, but that's just my personal opinion. Let's see how it goes. So Article 146, well, that's been it. We're hoping also that going forward, the Constitution Review Commission, based on what we've seen in these proceedings, would strengthen the provisions to make them better in future. I think that's what I can say for now.
See, and you're saying indeed the case that
It's been removed. I'm wondering what good it would do to continue the hearings. But in law, well, it's allowed because once the cases are still before the committee can go on. It would also be within the right of the petitioners to withdraw, to say, look, okay, if Madam Torkono has already been removed, they want to withdraw from having their cases heard. Yes, so that maybe, because you see, I'm saying this because let's also forget, Madam Torkono is fought this case every step of the way. My colleague, Wedam Puabri, has already, gone through, both of you have gone through the milestones, the, filing a case in the ECOWAS court, now the final one being the so-called group of the Bar of England and Wales jumping in, a letter that a lot of us had issues with in terms of its authenticity, not being signed, and the language in the letter, etc. But whatever it is, there was such, traction, that at every point she sought to fight back, and the various fora, etc. she's been through have resulted in a way, in giving us bad press. We can't run away that we've suffered bad press, a reputational damage to the brand name Ghana, because you see the kind of things that the so-called Bar of England and Wales wrote in their letter, the Commonwealth Lawyers Association also wrote earlier on. You see all that language taking us to the ECOWAS court, all those things, and the allegations of bias and all that, they've hit us. They've damaged us a bit. So for me, usually, if you can avoid litigation, avoid it. It's even in the Bible. But the Bible says that, hey, if your brother, somebody is taking you to court and you can settle the case on the way, settle it before you go and then you get thrown into jail, right? There is something like that in the Bible. So in this case, we are looking at protecting the brand name Ghana. We are quite a strong democracy in this sub-region, but globally, we are still a fragile kind of democracy. So when there are issues like this being circulated internationally, it reinforces the notion that we are still not that much capable of running our own affairs. So it's in that context that I was hoping that maybe the second and third petitions would not be gone into so that we can, have closure.
But you made the point about the Chief Justice challenging this process every step of the way. And the details as pages of documentary exhibits from both sides. Each side was...
From dispatches that we could hear, for them to have finished this quickly, they would go in the morning and close in the evening. So it was usually a full day's work, morning to evening, right? A number of days in the week. So it's been a lot of work. Yes, that one we can't run away from it. And in natural fact, we should commend the committee and everybody involved for cooperating for this work to be done in such a time.
Mm-hmm. And we know that the Chief Justice has a dual role. As a judge or a justice of the Supreme Court, and then also the head of the judiciary. Now, she's been sacked as the Chief Justice, essentially the head of the judiciary. What happens to her role as a justice of the Supreme Court?
Okay, yes, so with this, it goes the two of them. Yes, it goes for the two of them because it's not that she misbehaved as Chief Justice separate from being a justice of the Superior Court, right? No, they touch both offices because, yes, she's a judge of the Supreme Court and also at the same time Chief Justice. The matters that were raised are matters that if a judge, ordinary judge, were involved in and then there was evidence against that judge, the judge would be removed. So, in similar vein, since the Chief Justice is a justice of the Superior Court, and when we say Superior Court, that's High Court, Court of Appeal, Supreme Court, right? Yeah, so it's the same thing for Chief Justice and for any other judge of the Superior Court. Okay, so it can't be that she's been removed as Chief Justice, but she would come and continue as a Supreme Court judge. No. The law doesn't allow a Supreme Court judge to be engaged in the matters that were alleged to have been engaged in.
I see. And Counsel, stay on for me, if you will, just so we backtrack a bit. We recall exactly what the position of the now removed Chief Justice Torkono was on the petitions brought against her when she addressed the press conference detailing her concerns a couple of months ago. Take a look.
Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy.
What we're getting into is just a breaking news that came through some few minutes ago here on TV3. It's a statement from the presidency detailing reasons why that decision has been taken as upon the recommendation of the 5-member committee that the committee made their recommendation on to have her sacked. And on the basis of that established fact of stated misbehavior. Martin Pebu is private legal practitioner, is still with us. Dr. Joshua Zato is a political analyst, a lecturer, senior lecturer at the University of Ghana Political Science Department, joining us as well. Dr. Zato, good evening. Thank you for joining us.
Good afternoon, and thanks for having me here.
Well, also, Martin Pebu, you had made the point about the Torkono considering resigning right from the beginning of this process. She had a response for you and others who were making that suggestion a few months back. She says that that was really not an option on the table for her. And this was why. Take a look.
Resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number